I will elaborate on a few important cases within the South African courts. The first is the Zim torture docket case, which involved the confirmation of the principles of complementarity and universal jurisdiction. And this is essential because it was concerning a state which violations occurred in, but was not privy to the ICC jurisdiction. And where South Africa is, they were able to confirm its obligations to prosecute serious crimes under international law. I think an important factor about this case additionally is the strong collaboration between civil society actors, both in Zimbabwe and South Africa, that really led to successful coalition of evidence and data capturing and really pushing the advocacy to ensure that the courts ended up with the right decisions. I think two other cases or categories of cases I'd like to deal with is the prosecutions or the increase of use of customary international law principles in prosecution of apartheid-era cases, such as the Rodriguez case and currently an ongoing trial of the COSIS 4 matter. And these are cases that came before or arose out of the Truth and Reconciliation Commission. I think the third category of cases, which is really important, is the two cases involving the confirmation of the duty to arrest perpetrators that have been issued warrants under the Rome Statute, and that involves the former President Omar al-Bashir and President Putin. And it really reaffirms state duties and obligations where there may be competing political interests and international obligations. The fact of the matter is that we must always consider geopolitical pull factors, push and pull factors, and that will always be a decision that states consider when making decisions. But what we have seen in the past is even if the ICC and South Africa being privy to its obligations sometimes is reticent, that's where the role of civil society is really important to advocate, but also create the right environment to ensure that South Africa does comply. And ultimately, that is what we saw in some of the other cases. All states should be exercising the principle of universal jurisdiction. The challenge might come in, as I've mentioned, with the geopolitical discussions and whether or not certain states have more economic and political power that might dissuade certain actors. But having said that, I think it's important to know that in relation to international criminal law, it requires a certain specific skill set and expertise, which if you look at historically, I think a lot of African states have experience in this and learned really valuable lessons through various participation in criminal tribunals. And so where countries on the continent have this experience, we should be really increasing an exchange and better collaboration, not only between states, but also between civil society and amongst one another, but also cross-pollinating between states in exchange of information for better prosecutions. I think the final aspect is really leveraging the understanding of states on the continent, that this is not about moving away from a perception of, compliance is trying to hold them account for actions that they deem to be problematic and places them at risk, but more about uniting the continent and actually finding accountability for the atrocities that have happened historically. And I think if you approach it with this narrative and finding commonality and also reminding them, the AU themselves have made commitments around universal jurisdiction and where appropriate calling them out, but also using the right landscapes to find partnerships and collaborations would result in better implementation of the universal jurisdiction. I think the role of civil society in regional collaborations can definitely enhance the ability to prosecute successful cases using the principle of universal jurisdiction. I've mentioned two of the cases before, which was around the warrant of arrest and compliance with the South African court on the Omar al-Bashir case. Now, South Africa didn't just decide one day we're going to exercise this mandate. We worked quite closely as civil society with organizations based in Sudan and, collecting testimonies and evidence to ensure that when we presented a case, it was done in a very strategic manner, it was cohesive, and it was the best legal arguments put forward that made such a compelling case that the courts themselves felt that they had to abide by the decisions. The second case that I've mentioned was, of course, the Zim torture docket case. And it was not only about the close proximity of the borders of the two states, but really the fact that both states were collecting testimonies, ensuring that there was cohesiveness in this approach and that the standard of evidence documentation was at the appropriate level for litigation. And of course, the constant communication and coordination to ensure that if there were any movements, and I think this is an ongoing thing where there are open cases for prosecution, coordination of movements of perpetrators is really important, and mobilizing civil society to engage in their states where people are spotted in a certain jurisdiction where we can exercise these warrants, but also just from an advocacy perspective. I think what we also saw was in some cases, such as the apartheid era cases of Rodriguez, and even in Costas 4, civil society has really lent its expertise under customary international and international law broadly around the ability to prosecute crimes against humanity and add these charges with our national prosecuting authority. And that's really important to understand those different contexts, to ensure that people are working collaboratively. And after, attending the symposium and the civil society engagement over the past 2 days, it is becoming more apparent that where the ICC and the international mechanisms, of course, still remain added value to overall accountability, it is important more so that we find mechanisms in an innovative way for domestic interventions to ensure that there is justice for people that's rights have been violated. So I think broadly the legal challenges, of course, when the certain states, South Africa is not an example in this matter, but many states have still not ratified the Rome Statute, and the need to ensure that, customary international and international laws are embedded in domestic legislation is a first point. But when you move to the fact that even states such as South Africa have had domestication of international law, we have really met some challenges or reluctance by the state to implement. And this is, of course, the geopolitical factors that I've mentioned. What is important is that with analyzing the various states, it's important to see where there are strong mechanisms and institutions that we could leverage to engage and ensure that there is compliance. In the case in point with South Africa, it was a strong mobilization of civil society and other actors that have an interest in accountability and justice, but also leveraging a strong court, which as a mechanism, and the judiciary, which we can still rely on. So that's certainly something that's raised, but it's not the foreground argument they're making. And what we have seen is that it's really important for, states where they rely on democracy and rule of law and accountability and principles of justice to practice what they preach. And so we have seen successful models where you don't have to create, a whole different court to prosecute these crimes. It requires the expertise which, as I've indicated, civil society in appropriate circumstances can lend and support this work. Whereas, the overall result and the importance, I think historically, if you lend in on the the importance of justice and accountability with the 30-year democracy that South Africa has reached and the historical injustices in the past, it's really important for people to understand the importance of the prosecution of these cases to really have a purpose of justice overall, and that includes other avenues such as restorative justice and other mechanisms which might be appropriate. But I think the bottom line is that we need to pursue these as a matter of principle, but also full realization and transformation of countries and society. It's a mixture of appealing to their ego and the international reputation they hold in, especially with the recent case that they were involved in, but also appealing to their identity that is really set and grounded in historical injustices, and that South Africa still holds a very good reputation as a beacon of hope in the global south, but also on the African continent. And in doing so, that might, using those various factors and leveraging and leaning on them where appropriate, it might make them more receptive to some of these types of cases that they would take on, and not be perceived as non-compliant and only civil society intervening results in their compliance or intervention. That might be a good way to engage.